Good morning, everybody, and welcome to the fifth day of the India ADR week and the first session, which is being hosted by King and Spalding on the topic Abuse of Processes in International Investment Arbitration. We are very glad to have an esteemed panel of speakers. Let me take this to introduce them to you. We have Kenneth Bale, partner King and Spalding, Luan Tran, partner King and Spalding, Asim Chaturvedi, partner Khetan and Company, and Abhijnan Chaturvedi from partner ELP. I'm looking forward to an interesting discussion and hope all of you enjoy it as well. The video and the transcript for this session will be available on the India ADR Week website, which is adrweek.in. Over to you, Ken, and all the very best for a good session.
Thank you so much, Nidhi, and it's such a pleasure to be here. I only wish that we were in India doing this, but it's a pleasure to be doing this remotely. So we're talking about abuse of process in international arbitration, and I see that the title of our seminar says abuse of process in investment arbitration. I think we're going to talk about this a bit more broadly. We will cover investment arbitration, but we're going to cover all forms of arbitration as well, because this is a topic that comes up in arbitration in all of its different forms and manifestations. Let me start with a recent conversation that I had to set the context. I was talking to a former client that had been in arbitration proceedings for over a decade in Western Europe. I won't name the dispute, but it's a very public dispute that many of the participants in the webinar may have heard of. It lasted, 10 or 11 years and ultimately resulted in a result that was maybe unsatisfactory to all of the parties. But there were, during the 10 or 11 years, numerous procedural delays and issues and potential abuses. And when I was talking to the general counsel of this former client, they were saying to me, we will never use international arbitration again. We had no idea how susceptible international arbitration is to abuse of process, and we will never subject our company and its shareholders to the potential for these abuses ever again. We're taking international arbitration agreements and clauses out of all of our contracts. We're done with it. And he also mentioned that they had spent something in the neighborhood of $50 to $100 million in legal fees over 10 years fighting these proceedings. That anecdote I have heard from other clients as well. I've heard variations of this. And it's interesting because, I can remember 10 or 15 years ago attending conferences and panel discussions like this one, where the focus was very different. Back then, it was sort of the celebration of how wonderful and efficient international arbitration is. It was this flexible approach to dispute resolution that allowed the parties to design dispute resolution mechanisms and scenarios that were far more efficient than local courts and made abuses of process harder, or at least that was the theory. And so, I've seen in the last decade or two this interesting shift from attending conference and panel discussions that celebrated international arbitration as a solution to abuse of process, to now being on a panel today where we're talking about the problem of abusive process in international arbitration. And I have clients and former clients, like the one that I mentioned, who are complaining vehemently about this. So today, I think the issues that we're going to address are threefold. What is an abusive process in international arbitration? I have to say the definition is a bit fuzzy to me. An abusive process in some ways is the use of a procedural right in a way contradictory to how that right was intended. But beyond that, it's a little bit vague or wishy-washy. So what is an abusive process? Are abuses of process in arbitration a problem? A lot of people are talking about it, but is this really a problem that something needs to be done about? And then number three, if this is a problem, what should be done about it? What can we as counsel do about it? What should arbitrators be doing? What should institutions like the MCIA be doing? What should governments legislatively and judicially be doing about that? So that's what we're going to talk about. And just two prefatory remarks before we jump in. One is that when we talk about abuse of process, I think there are two types that we will talk about. One is sort of what I'll call classic abuses of process. And Luan will outline, I think, in detail what these are, but these are the typical abuses: delaying proceedings, really multiple proceedings, structuring your investments, and so on. And the second category is what Lucy Reed in her 2016 Freshfields lecture referred to as abuse of due process challenges. And I think there are relations between these two and overlaps, but they aren't necessarily the same. So we're going to talk about both of these and see what might be done. And I'm just going to offer one hypothesis at the outset, which may prove to be wrong or right, or partially wrong or partially right. And that is that abuse of process is an issue, and addressing it can be challenging, particularly for arbitrators who are in the best position to address it, for a variety of reasons. One is that abuse of process often happens where there are gray areas in the law that make these abuses possible. But arbitrators often aren't empowered to resolve these gray areas of the law. Number two, arbitrators often are afraid of due process challenges, and they don't want to overstep their bounds. They want to be very careful in the actions that they take, and therefore they sometimes indulge abusive behavior to avoid challenges to the ultimate award. And number three, even if arbitrators did want to do something about abusive process, their toolbox of potential remedies is a bit limited. So that's a hypothesis that we can talk about. And with that, let's launch into the discussion. I'm going to step back. We have an amazing panel and let them do most of the discussion. I'm going to start out before we turn to abusive process directly. I'd actually like to come at this for just a moment from the other perspective, and that is, arbitration historically has been seen as a remedy to potential abuses of process in national court that have run amok. And I wonder, before we jump into abuse, is arbitration still beneficial, at least in some contexts, in that way? Is arbitration at times still a solution to abuses of process? So why don't we start, Abhijnan? I'm going to start with you. Maybe you could talk about this in the NBN context. Do you think that there is still a role for arbitration to play in terms of overcoming potential abuses in the litigation system?
Thank you, Ken. Just to begin with, I'm firmly of the opinion that arbitration does, to a large extent, at least in the Indian context, help perhaps prevent the abuse of process, which may otherwise be seen in Indian courts. But I'll put that into perspective. We are an economy which liberalized ourselves sometime in the early 90s. We saw a new arbitration legislation come in the year 1996. And after that, both the legislature and the judiciary have in fact come up with decisions as well as amendments to the existing law, which has in fact, to a large extent, helped the commercial dispute resolution sphere in India. And I can totally relate to the fact that a lot of practitioners as well as stakeholders in the Indian context would be grateful to the fact that the legislature thought of the Arbitration Conciliation Act 1996 the way and the form that it is in today. We've had some seminal judgments by the Apex Court, which have in fact fostered the growth of an expeditious and an efficient commercial dispute resolution process within our country. Judgments like Bhatia International, which somewhat allowed the Indian courts to enter into sphere of an international commercial arbitration, which was seated outside India. It was sought to be rectified by the Balco judgment, which again had certain pitfalls of itself, which was subsequently bettered through legislative changes in the 2015 amendment. Post that, in the last decade at least, we have seen a proliferation of arbitrations within the country. And more so than ever, this is highly used by public sector undertakings, government entities, and it's it's not imaginable what would have been the situation had these arbitrations not been there, or had the arbitration legislation not been there. So in the Indian context, it has definitely helped a lot. It has streamlined a lot of procedure around a commercial dispute resolution process. It has given the parties the freedom to appoint an arbitrators depending on their subject matter. It has simplified a lot of procedure. I mean, it's not unknown that Indian courts are infamous for being sticklers for procedure. Arbitration perhaps bettered that scenario to a large extent in India. Um, there is a lot of arbitral institutions which are coming up in the Indian jurisdiction, which have again helped the arbitration jurisprudence a lot. The confidentiality of arbitration is something that, again, a lot of corporations as well as individuals would have appreciated to a large extent, given the fact that somehow we have a lot of media trials going on, which effectively will adversely impact a corporation. So all these sort of things have greatly impacted the development of commercial dispute resolution in India. And I can't even begin to imagine what would have been the situation had the arbitration legislation not been there. Something which has recently come up through the amendments in 2015 and 19 is that there is a defined period of time within which an arbitration has to be completed in India. I don't know how many legislations across the world have something like that, but we did introduce it in our legislation. And needless to say that while yes, certain arbitrations have run beyond the legislated period of 2 years, but most of the arbitrations and most of the arbitrators do look forward to completing the arbitration within that specified period of time. So yes, while there may be abuse of processes within the arbitration sphere as well, I would firmly believe that arbitration at least has helped, the arbitration legislation has helped a lot when it comes to commercial dispute resolution in India.
And Asim, in your experience, would you agree that arbitration still has a role to play as a force for good when it comes to process issues, or are you more skeptical?
No, thanks, Ken, for that. And I completely agree with Abhileen in what he's echoed, that arbitration in itself has been quite a speedy and an efficient manner in which commercial disputes have taken place in India. And like Abhileen was rightly pointing out, see, India geographically is a big country. And as it is, we are so overburdened with cases. Arbitration has done its bit to take that burden away from the courts. And especially in commercial disputes, where some of our courts do not have original site jurisdiction, even say a multi-million-dollar claim would go before a civil judge in a district court. So to imagine him being well-versed and equipped to handle a situation like that, I think arbitration has taken care of those issues. It has its own pitfalls, which we'll discuss during the period of this presentation. But one thing that I wanted to point out insofar as arbitration is concerned is that you have at least some sense of timelines, be it 2 years, it may extend by about say 6 months, 1 year. But unlike court systems where there is no timeline, if a client calls me from say a US and asks me how much timeline will a court decision take here, I frankly cannot tell him anything, especially costs. I may be able to tell him upfront costs that may be involved. So what arbitration takes care of is at least you have a definitive cost in mind. You have a definitive timeline in mind. So I would certainly echo with what Abhileen is saying, that it has been quite a boon insofar as commercial disputes are concerned.
And Luan, I'll give you the last word before we then turn the tables and look at abusive process. Your practice is very global. You practice in the US extensively, in Asia and elsewhere. Do you think, in your experience, that arbitration can at least times be a force for good? Or are you more skeptical due to the sort of the nature of your practice and geographic footprint?
Hello, and Thank you for allowing me to be here. Always good to come back to India, either in person or virtually. International arbitration is still perceived as more fair than the national courts in two main respects. The first is neutrality, and the second is procedurally equality. On the neutrality, I think the reason which probably best explains the success of international arbitration is the fear of the hometown advantage. And by that I mean that I think for a foreign party, national courts are generally perceived as not that neutral when they decide a dispute between locals and foreigners. It's well known that unfortunately corruption is present in a number of jurisdictions. And also it's well known that the independence of the local court is not a luxury in many jurisdictions around the world. Therefore, by submitting the dispute to a neutral institution, international institution, that relieve the party of the concern about hometown advantage. That's number one. Number two, on the equality, I mean, it's well known also that the arbitrator, one of the grounds to reverse an award, challenge an award, is the lack of due process. Therefore, experienced arbitrators, they pay very much attention to ensuring that the parties would have procedural fairness in the proceedings. Now, that's a good thing, but as you can see in the following conversation, that also could turn out to be an issue when dealing with abuse of process, or specifically when we have the inability of the arbitrators to effectively deal with abuses precisely for the fear of getting reversed in the enforcement stage.
Okay, so now let's, we've talked about the positives of international arbitration, which is a good place to start because we are all practitioners in this line of business. But having done that, why don't we now jump straight into abuse of process, what it is, how bad of a problem it is, and what should be done about it. And Luan, maybe I'll start with you again. I think in these discussions, often the participants in the discussion sometimes don't define what they mean by abusive process and what an abusive process is, nor do they sometimes explain why abuses of process are important to talk about. So could you start us out by giving us your definition of abusive process, and here I'm talking about the first category of classic abuses as opposed to the Lucy Reed due process abuses. What is an abusive process? Could you give us some examples of classic abusive process, and why does it matter? Can you challenge an award on this basis? Why should we care?
I think abuse of process can generally be defined as a conduct that is not per se illegal, but nonetheless can cause significant prejudice to the party against whom it is aimed, which undermine the fair and orderly resolution of disputes in international arbitration. So that's like the vague general definition. The doctrine of abuse of process is based on the principle, very simple principle, that every legitimate procedural right must be exercised in good faith. So you keep hearing the concept of good faith, the concept of fairness, which, as I mentioned earlier, is it's an advantage, perceived advantage of international arbitration. So good faith and fairness is very important. Now let's go straight up to the some examples or the categories of abuse of process. About 15 years ago, in a series of articles by very leading international arbitration practitioners, I think Ken, you mentioned Lucy Reed, but also the late Professor Emmanuel Gaillard, they started to write and raise the alarms about the increased problems with abuses in the process of international arbitration via a series of very influential articles. So Professor Gaillard, I think came up with a couple of categories, and I'm going to list some of them here, but also I added some of the other categories based on my experience. The first type of abuse is what we generally define as the conduct that's designed to secure jurisdiction or protection under investment treaty. So those are the kind of conduct that arise in investment arbitrations. So what we have, for example, oftentimes the parties with some claimant would try to restructure their companies so that they can fall under the protection of particular investment treaty. So in a series of cases, I think beginning in 2000, treaty cases against Venezuela, Ukraine, and Bolivia, each of those governments started to raise the defense of abuse of process by alleging that the claimants in those cases have improperly engaged in corporate restructuring or ownership so that they can benefit from the protection of the relevant BIT involving those countries. And that set the stage for the abuse of process arguments or claims made in the recent years. So that's one example of a way a party can manipulate the process. Number two is they can also, in this regard, come up with fake evidence of ownership to fall within the protection of the particular investment treaty. The second type of abuse that we see are cases where the same party filed multiple arbitral proceedings to maximize their chance of success. And we see that often, for example, where you have the same contract, but there are several breaches of the same contract. So some party would choose to file multiple arbitration, one for each, breach. Either they don't like the panel in the first arbitration, or they're trying to again maximize the chance of winning. Right? You can also see the kind of cases where in construction dispute case where there are several multiple claims in the same construction projects. Again, they file multiple arbitration for some reason I said earlier. Related issue, you would also see parties asserting like new arguments that they could have made or asserted in a previous arbitration. And that actually particular issue has come up recently in a case involving India, a fairly high profile case in which our firm was involved at the arbitration level. It's the union, it's a case between Reliance and India, a series of, POC and some oil projects, where the government of India has asserted some arguments that, according to the tribunal, our government should have asserted in the prior arbitration. And under the doctrine of res judicata, the arbitral tribunal has rejected these submissions under res judicata because they amount to abuse of process. And India went to the UK to challenge that award on that basis. And about 2 months ago, the commercial court in London has agreed with the arbitrators panel, saying that yes, what the government of India did was amount to abuse of process because they raised argument that they should have raised in the prior arbitration. The third type of abuse of process you can find is a claimant would initiate arbitration for purposes other than resolving a legitimate dispute. For example, they file a claim just to gain publicity or to exert extra pressure on the other side, to run up the cost, and create financial pain to the other side. Or also to avoid, for example, let's say one party is being subject of a legitimate criminal investigation or regulatory investigation of a particular country. That party would in turn file an arbitration claim alleging, this is unfair and violation of treaty protection. Those kind of claims could, in some instances, amount to abuse of process. So as you can see, the kind of abuse could be, it's pretty broadly, I think that it's up to the creativity of the lawyers involved. And unfortunately, we see more and more of those abuses across not only in investment arbitration, like Ken has mentioned, but also in regular commercial arbitration.
Turning to you now in the Indian context of your practice, what sort of situations are you seeing that might be characterized as opportunities for abuse of process? In some respects, I think the sky is the limit. There are all sorts of permutations that you might think of, but what have you seen recently?
So Ken, I'll just pick up from where Luan left. See, it's how it's very subjective what you call abusive process, and secondly, how imaginative your counsel is. So, in my personal experience, arbitration is process one. When you enter the arbitration proceedings, what leads to arbitration is an appointment of an arbitrator. And in 8 out of 10 cases where I have seen, I'm just taking a small anecdotal example, is where you have an option to appoint a sole arbitrator by consent. Any respondent who's not interested in taking this proceeding further will not respond to your notice invoking arbitration. When the matter goes to court for appointment of an arbitrator, it's already about 30 to 60 days are wasted by the time the party reaches for an appointment. Then there you don't appear on the first day, take time for notice to be issued. Then you come in and raise frivolous objections with regard to the maintainability of the petition. It may be the jurisdiction, it may be whether the dispute is arbitrable or not. While all of us are aware that in the scope of a section 11 is very, very limited in so far as our act is concerned. But we try all, tricks in the trade to try and even stretch the appointment. So if an appointment is taking 6 to 8 months, that in itself is half the battle won in so far as an abuse and delay is concerned. Now the Supreme Court has issued a whip that pending section 11 petitions of appointment have to be decided at least in a year. But this I'm talking about in more evolved jurisdiction like Delhi and Mumbai, where courts are sensitive to the process of arbitration. But if you go to more remote locations, where international arbitration isn't that much of litigation is coming in so far as the arbitration and the act is concerned, these proceedings itself can take 2 to 3 years of getting the arbitrator appointed. So that is also so to say an abuse where you are delaying the process. The whole objective of speedy justice is lost in so far as the Indian context is concerned. When I'm looking at an international arbitration, a couple of things that come to my mind immediately are emergency awards or emergency orders which are passed for granting of ad interim protections or interim stay. Now, till about very recently, even in an India-seated arbitration, an emergency award by an international arbitrator was not strictly enforceable. You needed to again file a Section 9 petition for enforcement of that award. What is the recent paradigm shift has been that India-seated arbitration in the Amazon judgment has been recognized, like an emergency award has been recognized that can be strictly enforceable under provisions of the Arbitration Act. But if you look at a foreign-seated arbitration, that is still a gray area. So wherever there are gray areas, they are bound to be exploited in an Indian jurisdiction. And like Luan and was pointing out, how imaginative a lawyer can get. You challenge the jurisdiction of the arbitrator, you file frivolous applications, keep filing one thing or the other. And those are the kind of things that are what I would call it as an abuse of process, because they hit at the very objective of speedy disposal of cases. That's been my personal experience.
Abhijnan, I'll pose the same question to you. What have you seen in your practice and are seeing recently that you might characterize as abusive process, and sort of how serious is this?
Right. So I'll talk about the conduct of arbitration proceedings in India and how we in the domestic arbitration sphere have experienced the abuse of processes. Actually, not just domestic arbitrations, the international arbitrations where there's an Indian party involved and somehow it happens to be an ad hoc arbitration seated in India. One of the very often and very much practice is the art of cross-examination, where parties go ad nauseum on cross-examination of witnesses. Now, is that an abuse of process? Technically, well, the respondent is just trying to get to the truth of things. And the point is that you are also trying to help the tribunal as well as trying to get to the root of things. But there has to be a certain limit. I mean, one of the arbitrations that we conducted, a witness was asked in excess of 750 questions. Now, that is just bizarre. I mean, you don't need to go on for more than those many questions. The tribunal could not say anything because, well, if tribunal says something, it can perhaps become a ground of impartiality or perhaps the lack of procedural equality being given to the respondent. So that is when it comes to cross-examination of witnesses in terms of the practice that we've seen. Another practice that we've seen is that the claimant will perhaps have a witness or two. The respondent, on the other hand, will have 5 witnesses, 6 witnesses, and they will not just depose on the facts and the evidence in the arbitration. They will perhaps depose on things which will go to the root of constitution of the claimant entity itself. So they will perhaps question the claimant's constitution itself during the evidence stage of a dispute resolution process. So, I mean, in the Indian parlance, there is so many more examples of this nature. Arbitration almost on the verge of completion. The respondent party comes up with 3 sets of application, one for enhancement of its counterclaim, the other for producing more documents on record, and the third for recall of witness. Now the tribunal rejects it. The counsel for the other side says that, this will be a grave injustice. This will be tremendously prejudicial to their client's interests, and the tribunal ultimately gives it. So while the main arbitration proceedings were closed for hearing, these 3 applications which were filed at the fag end of the proceedings, they still need to be heard. We still need to file a reply. And ultimately, the tribunal rejects it. And the rejection order is then challenged before a district court, who takes that order, procedural order, as an arbitration award, and then stays the entire arbitration proceeding. So this is a classic example of abuse of due process, and I'm pretty certain that I am not the only one who's experienced it. A lot of practitioners within this geography would have. Internationally also, it's not something that is unique to us as Indian lawyers. Internationally, when you look at the investment arbitration sphere, one of the treaty cases against Venezuela, there the arbitrator was challenged, I think, more than 7 or 8 times, and the arbitration is still running till date. So there are these constant examples in different spheres and in different geographical locations. The arbitrations which were invoked against the government of India, some of the arbitrators were challenged because they professed certain views in a conference or in a seminar. I mean, it's hard to imagine that what you and I may express at this particular panel may ultimately be used perhaps against you to challenge you as an arbitrator in an arbitration that you may currently be on. But these are certain realities of things, and I'll just take a minute more and stress upon the UNCITRAL rules as well. UNCITRAL rules in the year 1976, they said that the parties would be given a full opportunity of presenting their case at any stage of the proceedings. Now, the ingenuity of the lawyers worldwide perhaps pushed UNCITRAL to come up with another amendment in 2010, which said that the parties are given a reasonable opportunity of presenting their case at an appropriate stage. So, of course, there are these legislative and institutional changes, but to say whether these abusive processes will just somehow stop because of certain changes, I think our lawyer kind is way more creative, and we'll just come up with way more nuances.
Mindful of time, I could give innumerable examples from my own experience of abuses, but I'll tell you one that happened not too long ago. I had a case where the counterparty used every tool imaginable to abuse process because it was in their strategic interest to draw the proceeding out as long as possible. And we finally got to the end of the proceeding when it was time for the tribunal to render its award, or almost time for the tribunal to render its award, time for the final submissions. And the other party first started a process of firing and hiring lawyers. So they, would fire their counsel, and they would say, "We're now unrepresented. We need several months to find new counsel. new counsel would be appointed. Then they would say to the arbitral institution, now our new counsel needs several months to read into this complex case to prepare our submissions. And then right about the time that they had read in, guess what? New counsel was fired and they needed new time for additional counsel. And when an end was finally put to that, they then turned around and filed bar complaints against the members of the arbitral tribunal, counsel, parties to the case, on the claim that the arbitration was cited in country X, and that those individuals were not admitted to practice law in country X, which was the seat of arbitration. And there was clearly no requirement that the arbitrators and counsel be lawyers admitted in country X in order to arbitrate a dispute juridically seated there. But then they filed the bar challenge. Then they wrote to the institution that the tribunal now is conflicted because the tribunal has personal animus against them because of the bar challenge and they should resign. And it created a mess of epic proportions that took, many, many months to resolve. So it's a classic example of an abuse. Let me ask Asim, I'll pose this question to you just very briefly, and then we'll move on. And that is, are we being somewhat hypocritical talking about this? And when I say we, I'm not talking about the four of us, but arbitration lawyers more generally, because I have seen arbitration lawyers appear on Saturday panels and complain about abuse of process. And then Monday morning, they show up in a hearing that I'm involved in and they engage in the worst abuses I've ever seen. So, are members of our profession in some ways responsible for this?
Kenneth, well, I will unfortunately will have to agree to this, that we are to take the blame for the manner in which arbitrations are taking place. And I've seen it in India, I've seen it overseas, that we really need to have a dedicated arbitration bar now. It's high time. Arbitration is no longer a hobby for lawyers, that you will have it from 4:30 in the evening or on Saturdays or on weekends. And a lot of times what happens is that what could conclude during a weekday is pushed to the evenings or is pushed to the weekend. So you don't have so much man hours really to try and finish an arbitration. And the momentum gets broken in the whole process. Arbitrators, in India, arbitrators have a cause list of their own. They're so busy. The good arbitrators, you won't get dates. Plus, if it's a tribunal of 3, so 3 tribunal members and 2 lawyers matching 5 diaries in itself is a huge process. So I think we are to be blamed, but if I call it abuse, or will I call it a more of unethical practice to say, maybe I will take other views, maybe Abhijnan and Luan can pitch in here. I will not call it an abuse. I will really call it more of an unethical practice on our part.
And Luan, you provided the original definition of abuse, which I think I agree with. Would you see a situation like that as an abuse? Because I think there's quite a gray area as what constitutes an abuse and what is just maybe bad practice but doesn't rise quite to the level of abuse.
I think it's in the eyes of the beholder, right? The party engaged in that transaction, I think that's an abuse and vice versa. But I think the deeper question is, lawyers would continue to engage in bad conduct unless and until there's consequence to the conduct. And what's the consequences to those conduct? I think in the multi-billion-dollar case or hundreds of millions of dollars in dispute, sanction, of a couple of $1 million, I don't think it's going to deter this kind of conduct because so much is at stake, right? These kind of cases, increasingly big cases, multiple millions of documents, so on and so on. So I think that because international arbitration, especially at the high level, is still a fairly small circle. Well, a lot of people know everyone knows everyone virtually. I think that unless and until there's some kind of consequences, some kind of a shaming, to the lawyers who engage in this kind of conduct, either by publication of, awards, obviously the treaty cases where awards are public, highlighting this kind of abusive conduct, and articles like the one written by Professor Gaillard and Ms. Reed, as long as people continue to, to bring to to the public this kind of abuses, lawyers, will continue to do it without repercussion. I think the only thing that can set them straight is the fear of being ostracized by the fellow members of the small circle. And they might get away with that one time, but 2 times, 3 times, and get called out for that publicly, I think would make them think twice about doing that in the future again. Because in the long run, it's definitely not beneficial to their firm, their practice, or their clients.
And let's come back. I think that's an interesting point about the fear of ostracization. Being ostracized. Let's come back to that in just a moment. Abhijnan, let me ask you to pick up on Asim's example about the sort of dual practice that many lawyers have in India, because I just want to very briefly touch on this concern about abuse of due process challenges that Lucy Reed has talked about in her Freshfields lecture. This I could imagine might be an example of that. If I was a lawyer in India with a dual practice and I had to organize my schedule in a way that maybe wasn't optimal for the arbitration, but I just had to do it because it's the nature of my practice, and the arbitrator were to ask me about it, I might respond and say, well, my client has a right to choose their lawyer. And if you force me to appear tomorrow at 10:30 a.m. when I have a court appearance, that's going to deny him due process. And it might, scare the arbitrator away. In the same way that the example that I gave of the repeated hiring and firing of lawyers as a tactical matter, the argument that was made was one of due process, that a client has a right to decide who represents them. And if we've terminated our lawyers because we have a difference of opinion, we have a right to counsel of our choice. And so we should be given time for that. So what's your take, I guess, on Asim's example? Is that a due process issue? Is it a concern? And maybe more broadly, what are your thoughts about due process and how threats of due process challenges contribute to potential abuses?
So I do, to a large extent, agree with what Asim has said. In the Indian context, arbitration for a long period of time was after hours litigation, so to say. We did a lot of arbitration work, post-court work, post-court hours. During the pandemic, we've had hearings on Sundays and Saturdays with the arbitrator saying, oh, what will we do on weekends? Let's just continue with the hearings. So there may be a certain positive to that also, that, on a weekend when otherwise a lawyer may not be involved in court work, there is another dispute resolution that's happening on the side. But having said that, to a large extent, it can be taken as an abuse of process as well, because of the simple reason that while in larger cities like Bombay, Delhi, Bangalore, maybe Chennai, Hyderabad, lawyers may start conducting arbitrations on a weekday during court hours. The trouble is that there is a lot of commercial dispute resolution that happens beyond these cities, and of exponential sums of money of really complex disputes, where the practice is still the same, which would definitely prolong the process. I mean, if there are a handful of senior lawyers who will do this sort of practice, and if they are engaged in court work from Monday to Friday, it's highly improbable that they will have the schedule all the time. I mean, they're also human beings at the end of the day. There are only so many hours in a day. They will find it difficult to spare time for arbitration. And that is where, again, we go back to the after hours litigation practice. In fact, one of the judgments that came, I think, 3-4 years back, which said that seat of arbitration within the country can be in places which didn't have inherent jurisdiction to decide a dispute. That sort of judgment gave impetus to having seats of arbitration in Bombay, Delhi, Bangalore. But again, that is harmful for the jurisdictions where otherwise jurisprudence would have developed for a commercial dispute. But because you're concentrating on these cities, their sort of jurisprudence does not develop. So while there is much to be said on both the sides that, having arbitrations, conducting arbitrations beyond court hours may in fact be complementary to the fact that there is dispute resolution happening beyond court hours as well. It somehow, I think, will ultimately reduce time for the process, because there is that much more lack of time for the practitioners.
So I think now, we have talked about what are abuses of process, and we have secondly given some examples that highlight why abuses of process can be problematic. I think that takes us to our third topic, and I think we have 10 minutes remaining. So in the 10 minutes that remain, let's solve this issue. Let's fix it and come up with some suggestions about what can be done about abuses of process. Luan, I'll start with you. I think there are a variety of stakeholders: counsel, arbitrators, national legislatures, and arbitral institutions. Maybe starting with counsel. Luan, what do you think we as counsel could be doing better in order to minimize these sorts of abuses? You mentioned potentially putting peer pressure on each other and ostracizing abusers. Maybe there are other solutions. We can draft better procedural orders or arbitration clauses. What do you think are some possible solutions on the counsel side? And then just to flag it, Asim, I'll turn to you next to ask you the same question about arbitrators. Then Abhijnan, I'll ask you the same question about institutions.
I think that when we, as counsel, when we pick the arbitrator, select arbitrator, we want to make sure to select those who have a reputation of, have a firm grip on the proceeding, and would not tolerate abuses, and also who have a track record of making tough decisions in this regard.
Asim,
So a couple of suggestions that I had, and only picking up from where Luan has left. Say, supposing it's a complex construction arbitration, pick somebody who is well versed with the topic, not merely a retired judge who may not understand the complexities of what a construction arbitration has. So pick somebody who has domain knowledge and also has the expertise to understand, to cut short the time period which will otherwise be taken by an expert or in cross-examination. The second thing that I can think of is having very, very crisp and clear procedural orders, whereby you have strict timelines in terms of filing of applications, cross-examinations, inbuilt costs for delay. I think that can help in terms of structuring an arbitration to prevent abuse, or maybe if not prevent, bring the level of abuse down to some notches.
And Abhijnan, on the institutional front, one of the discussions that I always have when I'm in India is how to make India more of a hub for international arbitration seated in India. And the MCIA, which is hosting this, has done a great job of leading that work. And I know you're active with MCIA. What do you think, and I should say, feel free to talk about what you think counsel and arbitrators can do as well, but what do you think institutions might be able to do, if anything, to help with this issue?
I think the first thing is for the stakeholders to have institutional arbitration in their arbitration clauses. I think if we have institutional arbitration as a regular practice in our country, a lot of things can get streamlined. Your claims will get more conscious because you will have to pay commensurate arbitration fees. Today in ad hoc arbitrations, we ask for everything under the sun. We throw the entire kitchen sink, and out of a claim for say 100 million, only 10 million may be legitimate. So if we have institutional arbitrations, people will become more conscious of the claims that they will make, and completely resonate with what Asim said, that need to have experts in the field. So if you have institutional arbitration, they will also suggest arbitrators who have the subject matter expertise. And the arbitrators also will be more cautious of the timelines in order to perhaps have more appointments from that institution. So if they delay the proceedings, maybe the institution may not appoint them in the future. So all those sort of things may get a lot more streamlined if we do have institutional arbitration in the country, and a lot of a lesser amount of judicial interference in the arbitration process.
And I will just add, and then there's a question in the Q&A which I'll pose. But I think there's also a role for sovereign exercise of authority by legislatures and courts in terms of setting precedent, because often, I think as Singh pointed this out in some of his examples, often abuse of process results from gray areas in the law, and that is something that often only the state can clarify. There are also many opportunities for abuse, and for instance, rules regarding a classic one is service of process, where cases are delayed for years because of truly stupid and archaic rules on service of process that somebody should reform. Again, we could have another panel discussion on service of process rules. But let me pose one of the questions in the Q&A, and that is, what measures can potentially be taken against parties that force their counsel to delay and disrupt proceedings? And maybe I'll add a related question to that, which is, if you have a client that comes to you and is asking you and encouraging you to engage in abusive practices or practices that come close to the line, how do you manage it? So are there sanctions or consequences for parties that force their counsel to do that, and how can we as counsel manage it? I'll open it up to whoever would like to jump in on that.
I think this is a tough question, but I think it does come up, right, in practice as well. I think it's a case by case and also depend on the lawyer involved, right? I mean, if you truly believe that as counsel, you have a responsibility to the international arbitration community and advance the cause of arbitration, then, you might want to think twice about engaging this kind of conduct, even if that's what your client wanted you to do. Because again, I mean, after all, it's just one client, one case, and your reputation is the only thing you have in this profession. So that's a personal choice, right? And also depending on what the client asks you to do, because again, it could be subjective, right? So that's that. But I want to come back to what you said earlier, Ken, about what the arbitral institution or legislature can do. I think that they can come up with some rules, specific rules allowing or giving the arbitrators the tool or the power to dismiss claims that they consider to be abuse of a process. I've seen so far, the only thing I can come up with so far is the UN Convention on Law of the Sea, as you may know. They have a specific provision allowing the court or tribunal to dismiss a claim on the ground of abuse of process at the beginning. So they can decide not to proceed with a case if they found a claim to be abuse of process. Things like that can be done at institutional and state levels.
So I promised Niti that we will end on time on the dot. We have 3 minutes left on the clock, and we have 3 of you. So can each of you take 1 minute, and we'll go around and answer the following 2 questions. How big of a problem is this? And if you had a magic wand, what would be the one thing, if you could do one thing to improve the situation and reduce abuse of process? So is this a big problem or not? And what would your top recommendation be? Luan, I'll start with you.
It takes a village, right? I mean, people like to beat up on the arbitrator, but I think it takes the lawyers, it takes the arbitrator, it takes the institution to deal with this problem and issue. It's a real problem.
Okay, one vote for it's a big problem. Asim?
So it is a big problem, but I think we've come a long way from how bad things were to people taking it more seriously and things getting better and in shape. If I had a magic wand, I would really want people to, introspect and see how far can you push a proceeding and, hear your client and abuse the process. I think it's for one to, stop at a given point and then start following the process the way it should be. So maybe I would want people to introspect.
And Abhijnan, I'll give you the final word. What are your views?
I'm perhaps on the other side of the fence or on the fence over here. I think this is not a problem. This will persist. We will continue having more and more definitions of what is abuse of process and what is not. But magic wand in the Indian diaspora, at least begin with institutional arbitration that will resolve a lot of things for me, because there will be a predictability of the procedure, the costs, and both the arbitrators and the parties will be conscious of the timelines, because everything will have a cost implication or a cross-appointment implication for the arbitrator.
And with that, I will just conclude with two thank yous. First to Luan, Asim, and Abhiling. Thank you very much for participating. It's a privilege for me to participate in a discussion with the three of you. So thank you. And thank you to Nidhi and the MCIA. As usual, this is a fantastically well-organized conference and program, and it's been a pleasure to participate. And with that, we will wrap up, I think, right on time. Thank you all.
Absolutely. That's how arbitration should be starting and wrapping on time.
no abuses of
no abuses of
conference
time
process.
Correct. Absolutely. Thank you so much.
Thank you all. Take care.
Thank you. Take care.